All right. Well, joining us right now to talk about this Supreme Court decision, it is Larry the lawyer on the Harbor One hotline this morning. Hello, Larry.
Good morning. How are you?
How are you?
I'm fantastic.
Well,
beautiful morning to be talking about sports.
You were intrigued by this decision yesterday from the Supreme Court, which was a unanimous decision, which is, I think this court has actually been pretty unanimous, but it's not often that you get a unanimous decision from the Supreme Court.
Yeah, especially in significant cases, Greg. And, this is definitely a significant case. I think, the interesting thing about what you just said, Greg, is that it was the NCAA that appealed this case to the Supreme Court. The one loss that they had in the lower court, they felt like, hey, with a conservative, quote unquote, court, we're going to do pretty well, because I think that they mistook conservatism for traditionalism. And, I think that this decision shows that that's not always the case. Conservatism can also mean pro-business and pro-employer, or pro-employee, which is what happened here. 9-0 is very significant, especially in the light of the fact that the NCAA was banking on the conservative justices, that the newly appointed conservative justices, who really were the ones that led the charge in the dicta. The language that everybody's talking about today is from Justice Kavanaugh's concurring opinion, where he says, hey, it's highly questionable whether the NCAA and member colleges can even justify not paying student athletes a fair share of revenues. So the only reason they didn't go there is because they didn't have the ability to go there, because they weren't asked to go there.
But they're giving. But Larry, when they write a decision like that, when Kavanaugh writes a decision in that way, he's essentially telling the NCAA, don't bother coming back to us on this. Change your business model, because it's illegal. You need to be paying these athletes like they're employees.
So they definitely let them know, if we get this case again, this is going to be changing. So do it yourself. I agree with you, Greg, on that. What I think the interesting thing is here is, we have Brady's lawyer is the same lawyer that handled this case. And I think that's relevant because when you look at Deflategate, I think we could all agree that Brady had a really good case. The problem with that case that he had at the time was that the NFL has a collective bargaining agreement in place. And even though Brady might have gotten screwed a little bit and the case could have potentially gone the other way, what the court said in the Brady case was, hey, you've agreed to the terms of this collective bargaining agreement. So just because you agreed to these terms, which allow the NFL to do what they're doing, we're not going to change it. So if you look at the case that came down yesterday with the NCAA and you compare it to the Brady case, there are some real significant things that we can look at. The first is this. I can see that the NCAA would want to push to have their athletes unionized. I think that the NCAA will be doing much better if the athletes get unionized and there is a collective bargaining agreement, because to you guys' points today, if you have a blue chip prospect going to Georgia or Florida or Alabama or Notre Dame, they're going to want to negotiate their own deal. There's no question about that. And that could get extremely expensive. That's going to be unfair for the bigger schools versus the smaller schools in terms of the compensation packages. So I think that you're going to see the NCAA is going to want a collective bargaining agreement and potentially the unionization of all athletes, because, the lacrosse player and the water polo player, they're not going to be in a position to get the kind of revenues that the football player or the basketball player is going to get. A collective bargaining agreement makes that equal throughout all of the sports and all the genders of all the sports.
Wow.
So I think that's the one thing that you could see happen here that makes a lot of sense for the NCAA and makes sense for the general athlete, but, the blue chip athletes, the 4- or 5-star recruits, may not do as well.
Well, Larry, do you think that if they were to unionize, right, I think it protects, like you said, the colleges and giving them the ability to say, okay, we want to do it this way, not that way. Well, let's come to some type of agreement. But do you ultimately think that maybe those blue chip athletes are going to be able to make the money that they should be able to make through the name, image, and likeness, which seems like that's the next biggest domino to drop here on July 1st?
Well, I mean, I think that that's already starting to drop, Wiggy. Mm-hmm. And I think that athletes right now there are ways that athletes can currently make money on the name and likeness. So I think that that's the next step. But understand this, that's not really what we're talking about here, because that's not something the NCAA is necessarily going to have to pay these athletes for. Now, if ESPN is doing, a television commercial for, a big national championship game, and they're using, for example, Trevor Lawrence's name and likeness for the week running up to that game, yeah, that's a situation where name and likeness certainly could be used. But, it's just as likely that name and likeness can be used for, the guy that's in Alabama who's going down to Big Al's car lot, for the day. A lot of outside sources to pay for those name and likenesses as well. So I don't think that's going to hurt the NCAA as much. I do think you're going to see athletes getting paid. That's clear from this decision. It's just a matter of how that's going to be controlled by the NCAA. And I'm sure that if you're working for the NCAA today, it's all hands on deck in the legal department trying to figure out how to minimize this.
So when Kavanaugh in his explanation is talking about workman's compensation, he's suggesting that a college athlete who gets injured and then doesn't make it to the pros ought to be able to collect workman's comp for that, right?
Yeah, he is 100% on the side of the athlete, the employee / athlete, and he's saying, look, these student athletes have they have a great sacrifice. I mean, if you know anybody, Greg, your son played football at Division II, and the amount of effort that goes into maintaining a college schedule and the athletics, it's gruesome, And, these kids walk out of there, and most of them aren't playing professionally once they leave these schools. And a lot of them are walking out with, injuries that go on and on and on. And, especially now what we know about the CTE and some of these, other injuries that athletes get. I think what the justices are saying is, hey, the NCAA has gotten fat and happy for a lot of years. It's time to take care of the people that are actually making them the money. The other thing that's interesting, Greg, is the NCAA argue that, hey, what makes us different than a pro is that we're an amateur status. So because we're amateur status, we're not going to pay them. And, Justice Gorish, I believe it was, that said in his opinion, hey, just because you always did it that way doesn't mean it was right. So, they really shredded the NCAA on many different areas here. I think it's going to fall on the NCAA to do a complete revamp because, again, I don't think they're going to want this to go back to the Supreme Court, because it's very clear that the Supreme Court is looking at this as a situation where these athletes, if they were asked to have the athletes paid, they probably would have allowed the athletes to get paid in this case.
So, Larry, when they say that they're going to allow athletes to get these educational benefits, like, what would that mean for, because a lot of people out there probably are wondering, okay, what does that mean? How does this...
For me, it was Cliff Notes.
How does said athlete then get paid by the school?
So we're not talking about the athlete getting paid in this decision. This decision is limited to educational expenses.
Wiggy doesn't understand that the Supreme Court is sending a message to the NCAA, which I think is important. It's not this decision.
Right.
The message is, we expect you
to
as
get
a
it
court,
together.
Should we have to rule on this again, we expect you to pay your athletes as employees like any other business. Right, Larry? That's kind of what they're indicating.
And correct, Greg. And Ricky, to your point, what they're saying now, though, is that you can't limit the amount of money you're going to give a student athlete for educational expenses. So, think about it this way. If you're a blue chip athlete right now, how does this decision affect you? Well, I think hypothetically, if I was a 5-star quarterback going to Alabama, for example, I could negotiate a no-cut clause for my scholarship. Hey, no matter what, I want my scholarship. I could probably negotiate a 5th or a 6th year of my scholarship to make sure that I could graduate on time. I could negotiate potentially the opportunity to have the school pay for me to go to Italy and study abroad for a year. Mac Pro computers, tutors, all of those kinds of things right now are things that I think are on the table for an athlete to negotiate. And again, when I say negotiate, we all understand that it's not every school we're talking about. Most schools are going to say, yeah, you negotiate all you want. We're not doing it. But now they know that, the other boot is going to drop soon. So not only will it be educational, but, as Justice Kavanaugh said, his concurring opinion, this should be pay for these athletes.
Wow. Well, it's it's like a watershed moment when it comes to college sports, because you're not going back on this. So,
right.
All right, Larry, thank you.
Yeah, have a great morning, everybody.
All right, that is Larry the lawyer.